Now, Public Protector Busisiwe Mkhwebane is set to appear in the dock in the Pretoria Magistrate's Court on the 21st of January. She's facing charges of perjury. Mkhwebane is accused of being dishonest in the way she investigated a loan by the South African Reserve Bank to Bancorp, which now forms part of ABSA. Well, constitutional law expert Paul Hoffman joins us now for some explanation of what's going on there. Paul, a very good morning to you. And just take us back to, the Public Protector has been involved in so many stories, so many controversies at the moment. Just take us back to this actual perjury claim. What is it that she allegedly lied about?
Good morning, Rebecca, and happy reconciliation to you and your viewers. I think that the beginning of the problem, as far as we are concerned, and accountability now is the complainant in the matter out of which this perjury case arises, is that the Public Protector brought neither competence nor honesty to bear in her investigation of our complaint that the State Security Agency had wasted a lot of money in relation to clawing back the loot of the apartheid era. Part of that loot was the lifeboat that you mentioned in your introduction, where the Reserve Bank gave public money to banks that were in trouble in the dying days of apartheid. Now, the specific charges of perjury that the Hawks have investigated and have persuaded the prosecution authorities to now prefer relate to the way in which she explained her efforts in the investigation of the Reserve Bank and of the ABSA lifeboat. The Constitutional Court, which is the highest court in the land, was satisfied on a balance of probabilities that she had committed perjury in those explanations that she gave about meetings that she had with President Zuma and details of her investigation. The Hawks investigation of our complaint has now established that the prima facie case that the Constitutional Court has already commented on can be proved beyond a reasonable doubt, and for that reason the perjury case has been commenced against Busisiwe Mkhwebane in her capacity as the Public Protector of South Africa.
Well, Paul, like you say, the Constitutional Court did find that the Public Protector was dishonest in this case. So, should due process not have followed after that? Just explain to us why it is that you had to get involved and then lay the criminal charge, for those of us who are not afraid with the law, and what is supposed to happen when the Constitutional Court makes such a finding.
Yes, immediately the Constitutional Court made its finding in the civil appeal that it was seized with. We wrote to the Hawks. The Hawks are the police unit which is seized with the task of investigating serious crime. And it's clearly a serious crime if the Public Protector has committed perjury in the course of defending a decision she made in relation to turning the Reserve Bank into an instrument of state capture and ordering ABSA Bank to repay billions of rands. So our complaint has been investigated by the Hawks, and they have managed to satisfy the National Prosecuting Authority, whose job it is to prosecute criminal complaints that have substance, to now issue the summons that will see Advocate Mkhwebane in court on the 21st of January next year.
All right, Paul, just explain to those of us, who are probably wondering, with everything else going on, or all the other issues the Public Protector is involved in, why this is such a big deal. And just to look at what it says there, that Mkhwebane unlawfully and intentionally under oath deposed to an answering affidavit wherein she declared that she only had one meeting with the president, that's former President Jacob Zuma, on the 25th of April 2017, while knowing that the declaration was false. So that's what's stated on the charge sheet, explaining that first perjury count as well. So, in the bigger picture of everything, why is it? What are the implications of something like this? And why is it that we have to have these charges and she has to answer to a court about this when it comes to this issue?
Yes, our constitutional democracy is based on accountability and responsiveness to the needs of the people. And she has not behaved accountably in this matter from the get-go. We already complained about her to the Parliamentary Justice Portfolio Committee in January 2017, which is about 2-3 months after she took office, because she lied to us about the existence of the preliminary or provisional report in this same matter, and she went about running the investigation in a way that seemed to us to flout the procedures and the rules that are in place for an investigation by the Public Protector. So we were querying her competence and her honesty even before she committed perjury. And unfortunately, I have to tell your viewers that Parliament has done absolutely nothing about getting her to answer 13 questions that we asked her in order to give an account for what she had done way back then in January 2017.
All right.
Well, we know that her final report was set aside at the instance of the Reserve Bank and ABSA as well. And we know that the Constitutional Court made adverse findings about her credibility, about her propensity to lie on oath.
Okay.
We have taken that up not only with the criminal courts, but also with the Law Society, or what is now called the Legal Practice Council, because obviously advocates who lie on oath are not fit and proper to be advocates and should be struck from the role. And if she is not an advocate, she cannot be the Public Protector.
All right.
We've also today written to the President and asked him to give serious consideration to exercise the discretion that he has to suspend the Public Protector in favor of suspending her while this
matter is being dealt with. All right, Paul Hoffman, thank you so much. And just for clarity, she's not just been questioned about the meeting she had, but just the purpose of that meeting as well, or several meetings thereafter with the former president. Well, back to just what's happening in your